Good morning, everyone. Welcome
Hey,
back.
Jocelyn.
Good morning. Hey, David, how are you?
I'm good, thank you.
Good. I want to welcome everybody to our another session or workshop, rather, regarding the review of the Commission's transportation regulations. And we noticed this workshop on August the 2nd. There are some changes, recommended changes that staff filed as a result of our conversations at the last workshop. And that's what I hope we review today, in addition to any other issues that Nicole, Charlie, and David have. So, if we can, I'm Jocelyn Boyd. I'm employed by the Public Service Commission, and if you all will allow me to recognize Nicole, who's in the hearing room with us, would you please identify yourself and your client?
Of course. Good morning, Jocelyn. Good morning, everyone. Nicole Given on behalf of the Office of Regulatory Staff.
Thank you for being here. Um, David, would you introduce yourself, please? Next.
David Papowski, a member of the Charleston County Bar and longtime practitioner before the commission.
Thank you. And finally, Charlie.
Charlie Toraney, attorney, pro se.
Thank you, Charlie, so much. Thank you all for being present and participating. So, Nicole, David, and Charlie, do you have an issue if we start with just the insurance regulations first, and then we can proceed? I have my notes from the last session. Maybe we can proceed in that order.
No objection.
Yeah, no objection for me.
Okay, so I have a copy of subarticle 6, which we can display. Melissa, when you're ready. And everybody, if you recall, Charlie early on in this process brought to everyone's attention the liability limits in our transportation regulations, and the staff might want to look at those. And so after that, we contacted the Department of Insurance, and Ms. McGriff appeared on the department's behalf. She also filed some comments regarding her research related to other states' liability limits for motor carriers. Mm-hmm. And so we looked at those limits, and what you see, because we had a difficult time, as you can see on page, let's see what page this is, and this is in the docket 2020-247A. I apologize. I saw the page and didn't see it. Page 40.
Okay.
Okay. And
we're talking about passenger carriers here, or
passengers, yes, Charlie. These are passengers here, because I think that's more the concern. The limits for when carriers are transporting passengers.
yes.
So, everybody, I don't know the impact of the premiums as it relates to the limits that we've included, and so that's why you see the note there in blue. Should we discuss a phase in? If these are going to be the maximum limits, I just don't know I think we're trying to accomplish something here without it just being immediately defeated if the commission were to file these limits due to the maybe the affordability of those limits on the carriers.
Are these limits similar to those in other states, or
Yes, Charlie. So let me get my notes. So Ms. McGriff, her email is dated May 25th. And let's see. I think she gave us Georgia. Georgia's limits for 1 to 12 passengers is 100, 300, and then 50. And then for 13 plus passengers, the limitations are 500, 100, and 50. And then there's another note on the second page of her documentation. It says intrastate motor carriers 100, 300, 50. For North Carolina, her research found that for 1 to 15 passengers, it's 1.5 million. And then 16 plus, 5 million. And then for taxis, 100, then 300, and then 50. All right, and I think there was one other state, maybe Florida. Yeah, Florida's on the back page. It says 300,000 CSL or 100, 350.
right? You know, it would be good to know the premium impact. I'm sure there's going to be one. I remember back at the turn of the century, the commission, I think, informally proposed raising the insurance requirements for taxis from what were then the statutory minimum, which I guess they are now. And all these taxi drivers showed up crying poor mouth saying they were going to be put out of business. I don't quite believe it, but it sort of backed us off of it.
Mm-hmm.
And I imagine that's going to happen again.
Mm-hmm.
So it would probably be, because this needs to be done, but it would probably be a good idea to try to get some idea of what the premium effect would be.
Okay.
And then, armed with that information, I think, and I know this notice went out, and I'm sure it went out to everybody. I don't know who you sent it to actually, but at some point, I mean, I think a notice has to go to the motor carriers themselves, and you know, we're gonna have to face the music with them. And then if having done that, go to the General Assembly and say, you know, we've heard and we've considered, and I say we, I don't mean to be presumptuous, but taking into account the safety and whatever, you know, the commission arrived at the following limits. But I'm not sure I would do it without that information.
Yeah.
And
perhaps
Jocelyn,
the
sorry,
auto
Charlie.
insurance company could help with getting us some premiums.
Mm-hmm. Department of Insurance. I was thinking that too. Yes, ma'am.
Yeah, I
Nicole.
was going to, just to piggyback on what Charlie said, we agreed that a study of what the premium impact would be should be looked at, particularly because we felt that in our initial review the limits were much higher than they obviously are now.
Okay.
And we don't want to unintentionally create a captive market because carriers would be forced to cease to operate because they couldn't, for whatever reason, maintain the premiums on these policies. But I will say, and maybe I don't know if this is too early to comment on this, but we do support the idea of a phased-in approach with appropriate notice so that, if it happens all at once, you run the risk of there potentially being a compliance problem if people, the carriers don't know about it.
Right.
So we do support the phased-in approach.
Okay. So maybe the next thing is to reach out to Ms. McGriff and see if the Department of Insurance can provide us with any estimates on the premium impact.
Yes, we would support that.
And then I'm just wondering if I need to file this as a separate. I'm thinking I need to file just this section as a separate regulation. Everybody,
so.
like file the others and then file the insurance one separately. So, okay.
I think that might be a
Johnson,
good idea.
I have my hand.
Oh, I'm sorry, David. I didn't see your hand. I apologize. Yes, sir.
This is important. This is a big deal. Okay, because it's the first thing that a carrier has to have in place to operate. Okay, and it's one of their, other than labor and the purchase of equipment, is probably one of their bigger expenses. And when you say file this as a separate regulation, I would make this a separate proceeding. I think this needs to be highlighted. Okay.
Yes.
And I would consider, just to be certain you get a sufficient notice out there, that you separate this from all the, don't let it get buried in all the other little changes we're making here.
Right.
And make this a completely separate proceeding.
Right.
I don't know.
Yeah. What I would have.
I recently had to help shop for a client, a trucking client, not a bus client. And the insurance market is contracted.
Oh.
Okay. They're not as many as there used to be. And a lot of them aren't writing policies or out of fear of what they call nuclear verdicts. Okay, big verdicts against them.
Mm-hmm.
So the insurance market has gotten smaller. I don't know, Charlie, that's your experience, but I found that over the last month. I was shopping around for a client, so I would urge you to have this as a completely separate proceeding that gets the attention of all interested parties.
Yes. So what I think
Well,
I'll do, David, Nicole, Charlie, is we'll obtain that letter from Department of Insurance, whatever information we can obtain, and we'll post it in this docket. And then when we invite the motor carriers to participate and get feedback from them, we'll have a separate transportation docket for just the insurance issue, and then follow up with the notice of drafting and proposed regulation. But
if,
I think maybe we should, contact Ms. McGriff first to see what
yeah,
kind of information she can provide, and I'll post that in 247, and then we will proceed to open another docket.
and I would say it would, I wouldn't, I mean, I think we ought to invite the motor carriers, but I think it ought to be a broader public hearing. I would invite
Okay.
trial lawyers too.
Who
I
else
mean,
did you say, Charlie?
I hear what David's saying, but in my experience, $25,000 is woefully inadequate to pay the bills if somebody's injured in a car accident. And that's, we are just begging for a disaster. We're having a limo full of kids insured with a maximum of 50. I mean, it's crazy.
Well, Charlie, now you said who else? Because we can obtain a list, emails, and mailing addresses for all the motor carriers. But you mentioned another set of stakeholders.
Well, I mean, what I'm saying is it ought to be a broader public hearing.
Okay.
I could see the South Carolina Association for Justice
Okay.
having representatives, basically the same people who show up at the State House,
Okay.
because this is going to affect a lot of people, and the drivers are going to be the people paying the premiums, but the people paying for the injuries need to be heard too.
Right.
And defense lawyers and trial lawyers, I think, would have a lot to say about it. I know people that work both sides of that, and ultimately what they're arguing about is who's going to pay for these injuries.
Right. So, Charlie, I guess this is what I was saying. We would post it in the docket, and then we can reach the carriers through the notice. Do you
Right.
have any other, say the name that you mentioned, and we can just put it in the mail? That's what I'm saying. Drop those.
Yeah, if you open a docket, you might invite suggestions from interested for people to say, these are folks that we think should be invited. I would be glad to compile a list of my particular people.
Okay.
And I mean, you might as well go ahead and hear from the folks that are going to show up at the State House
Right.
when that regulation gets to the State House.
Correct. I agree. All right, and then what we'll do is we will invite them, and then on the notice we will ask the public to provide us with suggestions for other interested stakeholders, so that we can provide them with the notice.
Right.
Charlie, this is Nicola. I agree that the public should be heard too, just because, as the agency that's representing the public interest, obviously we support consumer protections. We just want to make sure that we strike the right balance.
Thank you. Now, David, I need you, please, sir, because I'm not I'm not on WebEx. Please just say, Jocelyn, I need to speak, because I won't be able to see at this point.
Oh,
Okay. Before.
hey, I was trying to be high tech here, Jocelyn.
Well, I'm sorry. Today.
I like that little hand,
The last time Randy Erskine was seated to my left, and so he could tell me when, so-and-so raised their hand,
All
but
right,
today I
I'll
don't have
speak
that.
up.
I don't have that luxury today.
I never interrupt Charlie Torino. So I understand that.
Well, I've got a thumbs up.
Oh, you? Well, thank you, Charlie, for that. I didn't see it, but thank you. Okay, so that's.
What I wanted to look, Jocelyn.
Yes, sir.
Madam Clerk, is that the federal there are federal limits, okay?
Yes.
And I haven't. I don't want to. I'm not so techie now that I can find them if I've minimized you guys and tried to look for them. But bear that in mind. Look at those.
That
And
might be,
it gives us cover. It gives the commission. It'll give the commission
Oh,
cover.
that's true.
And not when I say cover, I don't mean it in a pejorative way. To track what the federal government does. Okay?
Yeah. And you
that's
know
a
what,
great idea.
David, let me ask you this. Does this sound right? Now, this is on page 4 of Ms. McGriff's response from,
Yeah.
okay. Because the reference here is to FMCSA. It's the Federal Financial Responsibility Requirements.
Yeah. Federal Motor Carrier Safety Regulations.
Okay.
Administration.
Vehicle designed to transport 16 or more. There's a $5 million insurance requirement. Vehicle that is designed to transport 15 or less, 1.5 million insurance required.
Right.
Sounds
Were you
right.
thinking of something other than that? Other than this?
No, FMCSA is the feds.
Okay.
Yeah, I mean, it could be. It's expensive, but it could be. But I mean, I hear what Charlie's saying too. I mean, 25 is woefully low, but if that's the FM, that's interesting. Tell me, is this a letter from Miss McGriff?
Mm-hmm.
Are you entering that in the document?
It's in the docket. If you look on,
already
it should
there?
be. Yes, already there. It should have. And the watermark on this document says it was accepted for processing on DMS May 25th of this year at 2:32 p.m. And
Okay, so I didn't know that. I don't want to hold this thing up today. I'm gonna take a look at that next week. I'm
Okay.
curious about what she said.
All right. Yeah, May
Okay.
25th at 2:32.
Okay, I'll do that. Okay.
Okay. All right. And so if that is it, then we've included. It looks like Florida has followed what the federal government is doing for the 1.5 and the. Let's see, was that Florida? No, North Carolina. Yeah, North Carolina. North Carolina followed what the federal government is doing. It appears with the 1.5 million and the $5 million limit.
I know you can't see it, but I just posted a link in the chat to
Okay.
the,
Yeah, I
the
saw
federal
it.
requirements.
Jackie, can you get that for me? Can you take a picture of what Charlie posted in the chat?
Well, it's just a web link.
Oh, you don't see it? Okay. All right. Okay, let me. All right.
Maybe Charlie, why don't you email it to
I mean,
under
because I'll create some big ex parte. To
Well, they'll file the email now.
I have to email it to everybody in the docket. That includes water and sewer. And
Just write a letter to the commission and
100
insert
people.
this link.
my inbox
file
won't
it.
survive it.
Well, all right. We could all find it's public record. It can be found. It's in
Look
the
in your
rules.
chat
It's in
with
the
it,
application of federal motor carrier applications. You know, there are multiple places that can be found relatively very easily.
Look in the chat.
Yeah, I'm sure. Yeah, I see the chat.
Okay, there it is.
Okay.
Also, there's some. I like, but when you get off the insurance issue, I'd like to say one thing.
Okay. I think the remaining issues we've already discussed. The valuation, I think ORS proposed back on page 41. And then let's see
Let
if
me look at that.
there's anything else. Oh, yeah. And then we removed the Scrivener's error in 178 about the copies of proof of insurance. Nicole, we talked about that last time.
Yes.
And just left it in its original form. And that's under 103-178.
I do have a question, but
Yes,
what does
sir.
that mean? The valuation.
Oh, back to
that
this. See, Charlie, I think that this is used when in the tariff.
What
No,
page are you
I mean,
on?
what does it mean?
page-
What does the
page are
added
you on?
language mean?
Okay,
Where are you on?
I'm on
I
page
saw-
41.
41.
Yes. Intrastate valuation must meet the minimum requirements established by interstate rules issued by the Surface Transportation Board. Well, no, it's for claims, Charlie. I think it's how you value the goods that are being carried by the carrier. See, I think it applies. It's just saying for loss of damage carried on one vehicle, 2,500. I think it just relates back to how the motor carrier assesses the value of the goods being transported.
Does it change the 60 cents a pound?
No, I don't think so. He said, "Is it?" No, it does not. Nicole just affirmed it does not.
Okay.
Customer must be provided the terms, conditions, and pricing to the service being rendered. Okay, I'm all right with that.
You're good with that? Okay. You have any more questions, Charlie?
No, if it doesn't alter that, I'm fine with it.
No, sir. It doesn't change that.
Okay.
Okay. And so as we proceed with the remaining insurance regulations. Okay. So thank you, Jackie. So for everybody's sake, since we're now in this workshop, if you don't mind, I'm going to read the link that Charlie provided. If you don't mind, Charlie and David, Nicole.
Sure.
All right. It's https://www.fmcsa.dot.gov/safety/licensing-insurance- hire HIRE motor carriers with an S passengers with an S parts with an S. Thank you, Charlie, for that. Thank you, Jackie, for your diligence. We appreciate it. Okay, let's see. So we can now access that. Thank you for doing that, Charlie. Really appreciate it. We went over 178. And that's it. That's all of subarticle 6. I just wanted us to cover that. And thank you, everybody, for your input on the second phase, which will include insurance requirements, looking at the insurance requirements, a more thorough review. Okay.
Jocelyn.
Yes, sir.
Can everybody go to page 13?
Sure.
And look at new subsection 4 or section 14, the definition of driver or operator?
Oh, that's right, David. You did tell me just on that. I forgot just that fast. Okay, so David, on our page, I think that's, yes, page 13. There it is.
All right, let me just read this to make sure I got this right. Because
Okay.
I was thinking of that it means driver or operator shall mean any person who physically operates a motor vehicle under the jurisdiction of the commission. Hold on. Then it goes as an agent, lessee, independent contractor, or employee of any certificated carrier. Okay. All right. I get it. I thought it might have excluded the actual owner of the vehicle.
Mm-hmm.
You understand?
Yes, I do.
And I don't know if that needs, if you've got of any certificated carrier, which would be presumptively agent, lessee, independent contractor, or employee. That's all right, as long as you got of any certificated carrier. I think that implies the owner of the vehicle as well.
Well, maybe do you
Charlie,
think?
are you okay with that, or
I do.
Nicole? Yeah, okay.
Yeah, I'm okay with that. I would also be okay if we added in the word owner of a certificated carrier.
Okay.
I don't think we would have an issue with that.
Or any employee of. Hold on a
As long
second.
as long as it's the person who physically operates, yeah. If you want to put that in.
Yeah, as an owner, you might just write. You might add the word so it won't get confused. I might add the word owner as an owner, comma, agent, lessee, independent contractor. Right. You see what I'm saying?
I do.
Stick it in before the word agent with a comma after it.
And that's going to be, looks like that's going to be number 14. All right. Page 13. Thank you.
I have two more comments.
Yes, sir. Please proceed.
Go to page 20. Let me just make sure I got this right. And it fit, under fit, 4A fit.
There it is. Okay.
All right, the applicant must demonstrate the commission or the commission determines that the applicant's safety rating is satisfactory. Now, safety ratings are typically not in place when somebody applies for authority, and it takes a while to get them. Okay,
Right.
right? That's a federal manpower implementation issue. And all right, this can be obtained from USDOT and South Carolina Department of Public Safety safety records. Well, they may not have a safety record yet. Applicants should also certify that there are no applicant is financially able to do the business. Applicant further certified that is familiar with all this. All right, I like the familiar with all the statutes. So how do we get the applicant, the new fresh applicant who's going into the business for the first time? Okay, how do we get them past not having a safety record and not having a satisfactory safety rating?
Okay, so David, let me go to our applications, because those have to be approved by the commission, and I think we ended up adjusting the language in the applications. Hold on a second, to say if, let me just find the application. Okay, so I'm looking at the household good mover application, and I'm just gonna do a search for safety.
It's that separate page on safety, I think.
Okay, so Melissa, thank you so much. So this is the way we address that issue. But it says if applicable.
Yeah, we've always had that option to say no.
And then there's one that says pending here. Submit when received. Does that address your concerns, David?
I think I'm sorry, David.
Yeah, that probably does.
And Jocelyn, I'm sorry. So I had a clarifying point about this very section. It looks like, so when you go to the proposed language, there's no underline language there. So when I compare that to what is currently in the regs, it appears to be the same.
Maybe we just had too much fun highlighting. That's possible. Let me see.
I think it is the same, but
It is
David
the same.
brings up a good point. It's inconsistent with the application.
Fit. Yeah, that language does exist. So it's highlighted, not underlined. But I do think Charlie brought this issue up the last time. If not the last time, the time before last. If it was, I think it was you, Charlie, that basically said that which is why we ended up amending. I don't think the application as it currently read exactly this way before.
Maybe not, but it always allowed you not to have a safety rating, at least for the Class E's.
Okay.
Because remember, you would certify, if I don't have a safety rating, I swear I'll,
Right.
That's it.
I do.
comply with the traffic regs and stuff. So the thing, I guess what David's highlighted, and maybe I did and I've forgotten, is that the reg says one thing and the application kind of gives you an out.
Mm-hmm.
I just wonder.
I'm looking to see how it can be amended for those circumstances where, to include those circumstances where the carrier.
You could just put after satisfactory, if applicant, I guess what I'm saying, if applicant has a safety rating, it must demonstrate. You could just put comma if one exists after satisfactory.
Yeah.
Say that again. comma, what? If one
After
exists.
satisfactory, insert comma, if one exists.
Because it's almost like this is to me is akin to which the commission really doesn't require anymore, the equipment issue.
Right.
This is kind of like that to me. This reminds me of that issue. The carrier probably, a new carrier, it's possible the new carrier has not purchased equipment. Well, a truck.
I have never had a household goods mover with a safety rating. Never.
Mm-hmm.
I would say
I mean, I guess the problem is if you've got one that's got an is there such a thing? But I mean, I guess if you have an unsatisfactory safety rating, you want to know about it.
here's what I would do. Let me propose this language.
Okay.
The applicant must demonstrate, or the commission determine, that the applicant proposes to operate satisfactorily, period. Okay?
I'm writing.
And then, period.
Okay. Hey, David, what about in compliance with, like, what would our,
I would just leave it there and
okay.
Go ahead. Let me just finish this and I'll
okay.
I'm short of here. I would just say period. Take out the next sentence. How the commission determines that this cannot be obtained. You could say this may be obtained instead of can. Well, let's say this may be obtained from USDOT and SDP safety records if available.
I think the problem here is if you've got somebody with a really bad safety record, you want to know about it.
Mm-hmm.
As a matter of, course, most applicants don't have a safety record.
Right.
And with if the chance is out there that you've got somebody applying, I don't know even what a rating looks like, but let's say they've got an F from the USDOT, the commission needs to know, right?
Right.
There are 3 ratings by the USDOT: satisfactory, unsatisfactory, and conditional. Okay.
Well, if you had unsatisfactory, and you take this requirement out of the reg, a guy could come in and say, I swear. And you'd never know. I mean, so I understand why the commission wants them. It's just very few people don't have them.
Must demonstrate or the commission determine that the applicant shall operate satisfactorily. You know what? That first sentence, the revised sentence I just gave you, Jocelyn?
Yes.
I would use that, delete the next sentence that it can be obtained. And because the commission can always do that. It doesn't need to say that in the record. Okay?
Mm-hmm.
And then leave the rest of the paragraph as is. And the key thing is where they would certify that the applicant is familiar with the rules and regulations. Okay? That's an important sentence, that last sentence. Correct. In that section.
Right.
Because it makes the applicant swear.
We're not even having hearings anymore.
Yeah, but then they do that. It's good for them to say that. I always tell my clients to read the regs. Not, do you know the regs are? I show them the regs.
That's not what I mean. I'm talking about if they have an unsatisfactory safety rating, how would anybody know if you don't put it in, if you don't require it?
So what are you proposing, Charles?
I think you put a comma after satisfactory and just say if such rating exists. If you got a safety rating, you got to give it to us. I mean, otherwise, I suppose the ORS could just ask for it in the application process, but otherwise, if somebody's out there with an unsatisfactory rating, there's no way you'd know. You're not required to furnish it.
Well, Charlie, under this, should we say that then, that if the applicant has received an unsatisfactory safety rating, a copy must be provided to the commission with.
would just say if the applicant has a safety rating, it must be provided.
Okay, just take out
Say
is satisfactory.
Yeah.
So the first sentence is that the applicant has a safety rating, it must be provided, and then this can be obtained. I don't know if the Department of Public Safety has ratings like that.
Well,
I don't think they do.
I did speak to an officer before our last one. I think I told y'all that. No, that was dealing with the applications. And if I'm recalling correctly, they can obtain those USDOT.
Oh, okay.
Yeah.
Yeah, but I think the Department of Public Safety may do the inspection, but it becomes a USDOT rating.
That's right.
Right, but all the reg says it can be obtained from either one.
Jocelyn, if we wanted to decide, what's your time frame on this? I mean, after this workshop, what's the next step on all of the
Well,
on this?
we're gonna bifurcate this thing. So I would proceed with the notice of drafting for everything but the insurance regulations.
So if I wrote you a letter after this today, I'm just looking at. I'm a little worried about my time today.
You have two. Look, you have at least 2 weeks. My deadline to file notice of draftings is today. It's every Friday, every second Friday of the month. So I can't file another notice of drafting until the second Friday of October now.
Within 2 weeks, I'll write a letter and file with the commission proposing language for this.
Okay.
I'm happy to do that. How's that?
That's perfect. Thank you, David. So right now, though, just so everybody knows, I have, if the applicant has a safety rating, it must be provided with the application. The applicant must demonstrate, or we don't need the commission determines. The applicant must demonstrate it proposes to operate satisfactorily. And that's all I have right now.
Let me see. So the added, all you have right now is Charlie's proposal.
Well, I used what you have to at the end. So Charlie's proposal is what I read first. If the applicant has a safety rating, it must be provided with the application. And then we proceed with the applicant must demonstrate it proposes to operate satisfactorily.
Yeah, that's good. And then what's the next sentence?
We can still leave in this may be obtained from USDOT and SCDPS safety records if available.
All right, that's good. And
Okay.
then finish off. Yeah, I like
Okay.
that. Charlie, Nicole.
Yeah.
I'll take it back to my folks, but I think right now I don't see an issue with it.
Thank you.
Jocelyn, I hate to take us backwards, but can we
No,
go back to the definitions for a moment?
We sure can.
In
Which one?
particular, on page 13, the definition at 103, 102.8, Class C non-emergency certificate,
Mm-hmm.
and 103, 102.9, Class C stretcher van certificate.
Yes.
And then this would also apply to 103, 102, what will be the new 22, non-emergency vehicle. We're recommending striking the medically necessary language from each of those definitions, particularly because there are carriers who provide transportation for adults to adult daycare facilities, and those facilities are not, at least when I looked up the definition of medically necessary, they are not for the purpose of diagnosing and treating injuries or conditions under clinical standards. They might do some provision of medical treatment, but it's not solely for that purpose. So I think, and knowing that the notice of drafting letter, the next one would be the second Friday in October. I mean, we can propose some language. One of the things that we had sort of tossed around internally was using the words health related
Okay.
or something similar.
Okay.
But just so that there wouldn't be an issue with those carriers who are providing
Yeah.
transportation to adult daycare
Yeah.
facilities.
Okay. So let's see, using any motor carrier vehicle over irregular routes. I mean, unless we'll look at the phrase you provide, but just delete basically medically necessary.
Correct.
All right.
I think that's good.
So okay, Nicole, you said 8, 9, and did you say 22?
8, 9, and then the newly proposed
Yeah.
22.
Yeah. I see that. Okay, so that's on pages 13 and 14. Okay. Thank you.
And then Jocelyn, if we could go to the definition of fitness for household goods, movers, and hazardous waste. So 103, 133.1.A.
What page is that, Nicole?
Oh. Hang on a second, David. I'll grab it for you. I believe it's 19. Yes,
Yeah.
19.
So that we're back under 1A is fit.
Yes.
Okay.
Page 19. In 103-133.
1A.
1A.
Yeah, right. Okay, I'm there.
Okay. There is proposed language that the applicant is financially fit to do business as a certified carrier. My understanding from the application that was adopted was that there was no longer a requirement for assets and liability, basically for a financial statement to be included with the application. So
Yeah. But yes, because ORS said at the last one that if we included some language here, I thought y'all wanted the financially fit. If we deleted like the balance sheet from the application.
I don't recall
You don't remember
that.
I agree. I don't think that's necessary. Well, where are you? 8 fit? It's
Yeah.
under 8 fit.
Yeah, we're under page. Let's see, page
Oh,
19.
I see that sentence. Yeah.
Yes.
I'd be inclined to delete it.
Okay, y'all. Is it in? I think it's in the application. Watch this.
It probably needs to come out.
Let me look back because I remember us talking about this.
I mean, I don't know what it means, honestly. I've
See
had
that right there?
applicants who
It's
have
in the
two
application.
applicants rubbed together that got approved.
Because I remember us talking about that, y'all, at our application workshop. And you did, I think you, Charlie, and baby David brought up the fact, do you really need all of that?
Right.
And then there was another issue. Something in the statute about finance, something. Maybe it wasn't the statute, but I know we talked about this. And I think it was at the little workshop we had on the applications.
Okay.
That's how this ended up back, here. And we removed the balance sheet.
Nicole, you want to strike that sentence?
Yeah, well, so if we've removed the balance sheet, to me, if we leave the definition or the regulatory language as proposed, I don't know how they would demonstrate that they're financially fit to do business.
Yeah, I would strike that sentence. I'm with Charles. Applicants should also certify that no outstanding judgments pending against.
I mean, I think that's how you demonstrate you're financially fit. You don't have any outstanding. I mean, the problem with this is no one has ever settled on what it means to be financially fit. I mean, I've had applicants with 0 assets before.
Charlie, are you saying that they should certify that there are no outstanding judgments and put a period on that?
Yeah. I mean, if there are
I'm
outstanding
with that.
judgments, you got a problem. But I don't know that it matters how much money you got in the bank. I mean, because and if it does, we need to say how it does, because there's been no uniform.
No,
I've
I
never
don't think.
heard of anybody being turned down because they were financially unfit.
Jocelyn, I'd put a period after the word judgments and strike the rest of that sentence. I don't know, Nicole, if you agree with that.
You would get rid of pending against such applicant, David?
Yeah.
No.
Okay.
Yes. Oh,
You would
pending
get rid of
against
the
such
pending
applicant.
judgment.
Yeah,
So the-
period, after the word applicant.
After the word
Period.
applicant, and then strike the rest of the sentence, and that applicant is financially fit to do business as a certified carrier.
Correct. Yes.
We would agree with that.
Yeah, give me a second because I know we went through this discussion before and I'm trying to figure out. Okay. So is this passengers? So this is under household goods.
Mm-hmm.
Okay. I do remember talking to you all about this before, and my reason was that under passengers 4A, so I'm under 103, 133, 4A. I mentioned to you all that this sentence, which I thought was odd, talks about applicants should also certify there are no outstanding judgments and they're financially fit to do business as a carrier, certified carrier. That's how we talked about. I know we talked about this. I'm not dreaming this.
Yeah,
And it might have been in the context of the application. And I think I brought up the fact, why are the passengers required to have this requirement of being financially fit and the household good movers aren't? And this financially fit language has been in the reg since the last time it was amended. I know we talked about this. Now, if we want to change it, if you want to change it now, because I'd have to take the applications back to the commissioners for them to amend that, to remove it from the applications. But we'd also need to remove it from the passenger section. But y'all might not recall right now, but I'm quite sure we talked about this, and that's why it ended up, it was already in 4A, and that's why we went in and added it here after mentioning it. I don't know if it was in the workshop for the application or if it was in this one, one like this. So.
You know what? I mean, I get the feeling that if you have to take it back to the commission, it's going to become a thing. So I'd just say leave it.
I'm not against it. I'm just saying that's how we ended up there, because it was already. I thought it was strange that it was in the reg for taxis, but not in the regulation. The financially fit language was not in the regulations for household good movers.
Yet we've always required the showing, right?
I mean, I suppose if all they're doing is certifying it in the application, I mean, it still begs the issue, what is financial fitness and who's going to make that determination?
Jocelyn, are you saying we're leaving the balance sheet information?
No, sir. It's been removed, Charlie. For example, this is the new application that was approved over a month ago by the commissioners, and the balance.
The logical inference then from the regulation is that financial fitness is having adequate insurance and no judgments. So there's no problem leaving the regulation the way it is.
Right.
Yeah, I think you're fine.
Yeah, I just didn't want you. I'm quite sure that's how this discussion arose before.
Okay.
And
yeah, I mean, you're financially fit by having adequate insurance and not having outstanding
and no outstanding judgments, and
that's what the regulations require of you, and by having a lease or a quote for a vehicle, all those things.
I would agree. If it forces you to go back on the application, I'd leave it alone.
I wouldn't do it.
Yeah, I have to. They would have to approve.
Are you all right with that, Nicole?
Yes.
Okay. All right, Nicole, you had some more, I think.
I have one more, Jocelyn.
I have a few more. David, do you want to go first?
Yeah, let me go to page 49. Let me make sure I understand this. Copies
Page
of the lease
49.
agreement,
Okay.
use of leased vehicles, copies of the lease agreement. So if one of our people leases from U-Haul or Penske or something.
Oh, this part. Okay.
Oh man, let me make sure this is not applicable to the agreement. Must meet certain carriers may perform authorized and with motor vehicle plan which they do not own, only under contract lease or approved arrangement. Such contract lease must meet the following: it shall be made between the carrier, shall be in writing, shall provide lessee exclusive possession, shall be specified account be paid by the lessee used by the day, specified power units. Okay, so they get a normal Penske, U-Haul, or other leasing company contract. And then it says copies of the lease agreement shall be filed as follows. The original shall be retained by the certificated carrier. And whose power is to be operated. One copy must be retained by the owner. That's fine. One copy shall be carried on the power unit therein during the entire period of the Now, I find I've never asked a client, but I would bet that most of them don't carry a copy of that in their thing. And one copy shall be filed with the commission and provided to the RS. Each time, I mean, they lease vehicles on a daily basis and on a very ad hoc basis based on what their needs are. Okay. And the note, I think what got me was that a lease like that, a typical, just a lease of a truck, because they're busy and need an extra truck, that has to be filed with the commission and provided to ORS. So maybe Nicole, I don't know if you can speak to that in terms of ORS's experience with that. Change to more than one pair of copies and maybe maintain the additional power units. Okay. And that's such a day-to-day ordinary course of business for them to lease vehicles, turn them in. You know what I mean? I'm concerned.
Yeah, I do. I do. I'm trying to figure out because I had to look back at the entire regulation. I don't recall receiving these regularly at all. I'm not even
No.
sure people know about this.
I don't think they do. As far as I'm concerned, I don't understand why they would be filed with the commission. And I mean, ORS has the right to look at things like bills of lading or anything else. If ORS wants these leases, I'll leave it to ORS, but I don't really understand the filing period.
So I think what I'm proposing is that we take out this where it says or other arrangement and where it begins, and one copy shall be filed with the commission and provided to ORS. I would delete that. The remainder of that sentence.
Okay. Do you all use this in audit for audits or anything, Nicole?
I'm asking.
Okay.
My sense is it's the truck that's the most important. Maybe not so much the copy of the lease, but let me get confirmation on that.
You're checking with His Majesty Tom McGill, aren't you?
Wrong Tom.
What do you all call him?
Not Tom McGill, Tom Allen.
Tom Allen. Oh, you're wrong, Tom. You're right. Oh, sorry.
See,
Tom McGill is the font of all knowledge, or generally where Tom Allen would, and he reports to Tom Allen. Is that right, Nicole? I guess.
Yeah.
Yes.
I'm happy to let you move on from.
Well, I think Nicole has some more.
I definitely have a few more. This reg is for a company that doesn't own the truck but is exclusively using leased trucks, is what I'm being told. I mean, maybe we could move on and the three of us can powwow after this. Okay. That way we're not confusing things more. Does that work for everybody? Yep. Charlie, David?
That does.
Yes.
Yeah.
Okay.
Nicole, you're next.
Sure. Let's go back if we could to 103, 133, 6A1F. This is qualifications for drivers, and I believe it's not emergency, but let me go back in my document.
Give me a page number.
21.
31?
21.
21.
Okay.
So this is about the safety training that drivers have to complete. And I think there's been some back and forth here. We would prefer that it say the driver must complete 12 hours of in-service training annually, 6 of which must be CPR and first aid, and 6 of which must be in the area of safety, which is different than what is proposed. The 6 hours of in-service training here in the reg as proposed doesn't include CPR and first aid. We want them to have 12 hours cumulatively with 6 devoted to safety and 6 devoted to CPR and first aid.
So what do you want us to do? It currently reads they must complete 6 hours in-service training annually related to passenger and vehicle safety. So you want it to read the 6 hours of in-service training shall include CPR? Just remove the word
So
not.
driver must complete 12 hours of in-service training annually, comma, 6 of which must be CPR and first aid, comma, and 6 of which must be in the area of safety.
What was the last six of which?
And 6 of which must be in the area of safety.
And so, all right, so I have driver must complete 12 hours of in-service training, comma, 6 of which must be CPR and first aid, and 6 of which must be in the area of safety. And then the next sentence begins with the word records.
Yes. Can we go back though, Jocelyn? It should be driver must complete 12 hours of in-service training annually.
Oh yeah, okay.
So this would be
I just didn't read it.
Okay.
You're right. I see that now. Thank you.
You're
12
welcome.
hours of in-service training. I didn't strike that word, but I am striking related to passenger and vehicle safety. I'm removing because it's new. The 6 hours of in-service training shall not include CPR or first aid training, and we would end up striking in the area of safety.
Correct.
I mean, we can strike it or we cannot. I mean, depends on how we modify the sentence. But that language remains at the end of the sentence.
Mm-hmm.
All right. So that's on page 21, and that's 103.6. Capital A, 1, the number 1, and then F. Okay.
And then if we could move to page 22.
Before you go to that, just to be clear, that doesn't apply to Class C drivers. This is just passenger.
This is non-emergency.
Non-emergency.
Yeah, okay, then. Okay. All right, thank you. Go ahead, I'm sorry, Nicole.
No, that's okay. Page 22 under proposed subsection J where it says driver's license.
Now, is this B? Oh, no.
No,
We're in
no.
the same section. I see.
Same section.
Gotcha.
This is in the driver's license proposed reg. We would just point out that this is already required by DMV regulations, so to avoid redundancy, we think it could be struck. But I don't know that there are such strong feelings to it as if Charlie or David felt strongly about it. I think we would be fine, but it's already required by DMV regulations.
Doesn't matter to me.
Yeah, it doesn't matter to me either.
David, do you have a strong feeling about that?
No.
Okay, then I think I'd recommend striking it just to avoid redundancy.
We'll remove it because this is new language. We'll just remove it.
Remove it.
Okay.
And then in the section, the proposed section that immediately follows the sex offender registry, the last sentence reads, any driver who is placed on a sex offender registry shall notify the ORS and the certificate holder under which they operate of their status and shall immediately cease to operate their motor vehicle. We would recommend, rather than saying cease to operate their motor vehicle, saying immediately cease to operate as a driver.
No objection.
Fine with me.
Okay.
And I don't want to belabor this at all, but I'm just going to raise for information. You're asking for a criminal background check, but and I don't think you're doing that for the Class C drivers, which is good, but
Yeah, we
What do
don't
I
do
do?
that for anybody anymore, Charlie.
well, it's in here, page 21,
Page 21.
bottom of
Okay,
21.
so that though, I think, let me go back, Charlie. They must comply to meet the following requirements. Maybe that's in their records. Let me look, because I don't think we get those at the PSC anymore. We struck those from the application. Anything related to a criminal background check. Yeah, Charlie, I'm not sure this has like. I'm not sure this is filed with the PSC.
Okay,
I know it's not in the applications anymore. I think it's
okay.
required. Nicole, would you opine on
If
this,
it's
whether
just
or
to
not this is
maintain
for
it,
their
I
records?
don't know.
Let me see.
I
Which
really
page
don't.
are you on, Jocelyn?
I'm
I'm
on
sorry.
page, no problem, the bottom of page 21. Charlie just referenced the criminal background check.
Subsection little I.
Yeah,
Okay.
thank you.
And Charlie, can you repeat your
His question was, why is it required? And I just made a note that the criminal background check formal requirement that it be provided or any reference to it in the applications is no longer, that language no longer exists in the PSC's applications for motor carriers.
I don't think we
I
would have
don't
it.
I'm sorry.
No, go ahead, Charlie.
I don't have a problem necessarily with it, but again, I mean, the point is, what about it? If you have a national criminal background check and there are things on it that are going to exclude the driver from being a driver, we ought to say what they are. If they're not, then what do you? I mean, it can't be arbitrary. Is my point.
Well,
I
Charlie,
would delete that.
let me ask you this.
I mean, I get it. If the guy's been convicted of rape and kidnapping 3 years ago, that may be a problem if he's carrying passengers around. But we don't say it. And so if he's been convicted of shoplifting 20 years ago, if he has a marijuana offense when he was in college, I don't. This was the problem I used to run in with movers in the application process. You know, okay, we have a criminal background check, but what's our standard for excluding somebody? So if he's got to maintain this criminal background check, it must be for a reason. What's the reason?
Charlie, I don't know that this directly speaks to your point, but my understanding is that the national criminal background check has to be kept in the driver's files that the company maintains. I don't know that that directly speaks to your point, but that's my understanding.
Well, I mean that. I'm glad that it's not part of the application process, but I guess what I'm saying is why.
Like, why
And
should
I'm not
the, why
saying
should
there
the,
aren't, there aren't legitimate reasons to have it, but we don't say what they are. So if ORS comes and inspects and says, okay, let me see your criminal background check. Okay, here it is. Long as a telephone pole. What are you going to do with it? Does that mean he's not qualified? What offenses are disqualifying and what offenses are not? Because otherwise you start running into a problem. And I mean, there are all kinds of issues raised by criminal background checks and employment screening, for instance, of discrimination. So I think if you have criminal background checks, you need to know why, and you need to know what is going to be a problem and what's not. Just like some crimes will keep you from voting for a certain amount of time, and some won't. But I mean, the law says it's not like we look at it and make a case by case determination on whether you get to vote.
Josh, can I speak?
sure.
Maybe Nicole, you need to just go. I think maybe y'all need to, ORS needs to caucus on this itself, and then get back on that one.
Sure, we can do that.
Yeah, and it's not a huge deal.
ORS may have valid reasons or whatever.
I'm not saying there aren't. I'm just saying we probably ought to say
I
what.
think input from ORS is central to this.
Yeah.
In that vein, going back to that lease point, how about Charlie Johnson with this work? You said it's 2 weeks. I'll look at that lease provision and I'll email Nicole and Charlie on trying to come to a consensus on it, and then I will write a letter to the commission copying them. Will that work, Nicole, Charlie?
That works for me.
Yeah.
Okay.
Jocelyn, could we move to page 32, please? And this is just before subarticle 5 begins. This is 103-140, the request for extension to comply with the commission order that's being proposed, particularly the second portion of that proposed reg. I'm looking in particular at the second sentence. Exceptions of up to 1 year will be considered due to cause. I guess there was some confusion internally over what the intent is here. Is it meant to be such that there are certain reasons that the commission would not accept a request for an extension? Because there's no standard that's articulated here. And I think in my experience, as long as there is some sort of reason that's being given, the request is normally granted. So I think the due to cause is confusing.
I think the thinking there was that the applicant requesting the extension needs to state a reason and not just, I want an extension until December 31st, 2022, and not say why, indicate why.
Okay.
So that's what that is. If due to cause needs to be some other word, but that's it. We don't want to. I think they're more comfortable considering and ruling on. Need an extension. Here's the reason why.
Well, in the first portion of that proposed reg, it says that they shall include the current deadline, the requested deadline, and the reason for the extension.
Mm-hmm.
So if you move to the second portion of that reg, I think you could just say extensions of up to 1 year will be considered, and then period, strike the due to cause. And that way, if they don't give a reason, then there's sufficient, I guess, in my mind, there would be sufficient justification for the commission to not grant the extension if a reason were not given, if that's the intent.
Okay, well, I'll look at maybe cleaning it up. Extensions for 1 year will be considered. I'll look at that. I think that we included that first sentence, the second sentence to lead into the third sentence. This is what will happen for year one, up to year one. After that, the third sentence, if it's beyond year one.
Okay.
But let me check internally to make before I just delete that. I think someone was that you, Charlie?
I was just asking, what does the third sentence mean?
The third sentence is if you request an extension, I think beyond 1 year after the date of the commission's order. Extensions beyond 1 year. So if it's today, so next year, this time, well, let's see, the 10th, September 10th. If you ask for an extension, you will be required to reapply to ensure that the information the commission is considering in your application is current.
Jocelyn, may I ask a clarifying question on that? Would it be extensions beyond 1 year of the original application that was filed, or the request for the extension?
No, I think these are for the commission's order. Request for extension to comply with the commission's order. So I think there are certain deadlines that are provided in the commission's order.
I see.
90 days or, along those lines.
Right.
So if
That's correct.
it's
Okay.
over a year, I think after the commission has granted the certificate, I think
Then you would have to reapply. So it's based on the
Yes.
timing of the commission order. That makes sense.
Yes.
Thank you.
Yes. So I'm making a note to look at the language due to cause. I don't want to delete that entirely, but maybe I can clarify why we differentiated year up to year one and year one, beyond year one. Thank you for saying that. Yes, ma'am, Nicole.
Could we move to page 34?
Okay. Okay.
And this is 103, 151, registration of motor vehicles, and then it's subsection 4 of that regulation. And this is just a cleanup matter.
You said one. I'm sorry, Nicole.
Yeah, sure.
103. You said 15?
151.
Oh, 151. I was there. I just didn't. Okay. All right.
And then subsection 4 under that reg. We would recommend striking semi-annually in advance and the comma that follows advance, as well as and July 1st. And this is just, I think, because statutorily the new process is the annual fee has to be paid by January 1st of each year.
All right. So just it will read must pay the appropriate license fee, comma, on or before January 1 and July 1 of each year.
You would also strike July 1, so
Oh,
it would
you
be
said
on or
and.
before January 1 of each year.
On or before January. Okay, great. Thank you.
And I have one more, but I want to give Charlie and David an opportunity too.
Go ahead.
Okay. The last one, let me see the page. This is on the next page, page 35.
Okay. Next page. Yes, ma'am.
103, 153, the marking or identification of vehicles. And this is the proposed subsection 4 for exceptions.
Okay.
And I will be completely honest, I don't completely understand this section.
Oh, gotcha.
I'm not sure who this is supposed to target versus not target, and I think that's part of the
Oh, the exceptions?
yes.
Oh, yeah. So I think this targets people who, I think some of the concern with staff was making sure that the commission, sometimes the commission will receive requests for carriers not to have to put placards on their vehicles. And so that it doesn't seem as if the commission is favoring one class or type of motor carrier over the other.
Okay.
Just because someone could pay more to potentially ride in a limousine than in a taxi.
Mm-hmm.
And if the commission continues to grant requests to exempt certain, in its orders, to exempt certain carriers from having to include or place placards on their vehicles, I don't think there's been any we couldn't find any justification in the regulations as to why they can't. There are orders that allow certain motor carriers, they ask for the waiver. I don't want to put it on because of the nature of the move, or not the move, the nature of the transaction. They're taking someone to the prom, or it's a nice dinner, whatever, and they might write the commission and say, due to the nature of our business, and we'd like to ask a waiver of this regulation.
Mm-hmm.
And the commission has considered those in the past. But there's nothing in the regulation as it currently exists that indicates why or when the commission would grant an exemption. I hope that's clear on the history. So that's or an exception. The intent here is to come up with or create a threshold, I guess, for when the commission will consider requests from exemptions for marking, for placards on vehicles.
Okay.
This is David. I don't think that really comes up in household goods carriers.
It doesn't.
Right. I mean, and
Limos.
maybe the answer is then listing out those classes that would not be eligible for an exemption, or to which this proposed regulation wouldn't apply.
I don't know if they're gonna. I don't know if they. I don't think that was the goal
Okay.
here. Is there confusion like from ORS about why we included this as new language? Is that what's going on?
That's part of it. And I think maybe what we could do is we could caucus internally and maybe come up with some alternative wording to suggest to the commission for you all to consider.
Okay. Have I adequately explained though the reason why we were looking at this? Because there's not a standard right now as to who, when the commission considers those requests.
I mean, I found the explanation to be helpful. So
It's usually limos, right?
Usually, yes, Charlie. Was that all you have, Nicole?
yeah, that was
Okay.
it.
David, do we need to come back to you?
No, you don't.
Oh.
I'm done.
I have one.
Okay. Which page?
Well, it's 101, 134. I'm looking.
Okay.
Page number.
So we're probably looking around page 23, maybe. 24.
Probably. I should have written the page number down.
No, actually, we're looking at.
28 and
Thank
29.
you. Thank you, Nicole. 28, 29. Oh yeah.
Okay.
Okay.
All right. This is the application process.
Yes.
And I'll be the first to say, this all looked great to me until I looked at it again this morning and I was reminded of a particular case I had. Because right now what we say is the commission, if an objection to a motor vehicle carrier application is filed, the commission must hold a hearing. And that sounds great. I mean, because that means either ORS has objected or someone else has objected, and so we need to have a hearing, and otherwise we're not going to have one. So I'm good with all that. But I'm reminded of the case I had last year in which a competitor filed an objection to another applicant's application just to hold them up while they were obtaining a non-emergency certificate. And the commission rightly didn't hold a hearing on that. The commission understood it for what it was and dismissed the objection, granted the motion to dismiss. It still took a little bit longer than I would have liked, but that wasn't the commission's fault. That was just the process. Is there any room here for the commission to say this isn't a valid objection?
So I remember you and Jack talking about this at the last workshop. And I think, Charlie, I tried to cover your concerns about that in number 2. Now tell me what I missed. Objections shall set forth clearly and concisely the facts from which the nature of the petitioner's alleged right of interest can be determined. That might be too much.
Anything in 2. My problem is, my only question, and you may tell me this isn't a problem, but it says if an objection to a motor vehicle carrier application is filed with the commission must hold a hearing.
Can I show you where I got that from, Charlie?
Yes, ma'am. Is it from the law?
It is.
Well, in that case, there's nothing we can do about it.
Okay, I'm ready. Thank you, Melissa. It's right here, Charlie. It's in the new 5823-210.
Okay.
And it's capital B and then number 2 right here. If an objection is filed with the commission must hold a hearing. That's where we got that from.
Well, I think there's nothing you can do about that.
Okay.
Is there some way to put a time limit on it, like the hearing within
Oh.
60 days?
Okay, I see. So let's see. I do know we just have to give, over here it says we have to give not less than 30 days.
Yeah.
Published notice here, not less than 30 days before the date. And I think what you're saying, a time limit, maybe a notice of hearing, setting the hearing, kind of like the citing act, where we have to set the hearing.
Within 60 days
Yeah,
or something.
yeah,
I'm just
yeah.
thinking of that My Ride situation where, he's on the docket and somebody else is on the docket. They object to his application while they go ahead and try to get their certificate.
Okay, so I can look at after this last sentence here, after it says it shall include the time, date, place, just adding a sentence there saying the hearing must be held within, what are you recommending?
60.
So within 60 days of the filing of the objection?
Yeah, and correct me if I'm wrong, the commission would still have, under kind of its general waiver powers, would still be able to extend that for good cause if either ORS or the applicant asked, or both of them did. And so we
Yes.
need to-
Because it's in the regulation, yes.
Yeah, so I would say, 60. So at least it moves along. And I never would have thought of that until that case last summer. Or last year.
Okay, I'm making a note.
Thank you.
Mm-hmm.
That's all I've got. I mean, I think you've done a really good job of this.
Well,
I agree.
Agreed.
It's a team effort over here. So thank you on behalf of the commission staff.
And I want to thank the Department of Consumer Affairs for all of that. It's been invaluable.
Well. All right, I'm gonna peel off. Everybody have a good weekend.
Bye.
Bye, David.
See ya.
Bye, Jocelyn.
Bye, Charlie. I'll see you next time. Thank you.